European Union is the common market and a system of the creation, the construction of a system of unrestricted competition, so an economic objective, surrounded by the monetary union as well as some partial competences such as environmental policy, such as tourist policy. The Lisbon Treaty gives access, or gives the Commission access to the full scale of domestic policy, from tourism to space policy, and the national legislator would not be able to resist that legislative offensive from Brussels. If ever there is one particular right or power which is insufficient for the European Commission or for the European Community, the article, the self-authorization article 308 gives the Commission and the Community the power to act in the name of implied powers, saying that we need some additional powers to implement this or that policy. So this makes a great qualitative change between the economic community Europe has remained, has remained till Maastricht, essentially, whereas from the Lisbon Treaty onwards, the community becomes a full-scale political community which interferes into classical fields of internal policy, such as justice, the administration of justice, and the cooperation of police. The European Community, through the Lisbon Treaty, makes what we call in Germany ein Quantensprung, a jump, an enormous jump forwards. And if we retroactively look at what how the European Community has behaved in the past, we can only make a prophecy. If the process of unauthorized initiatives goes on, the Lisbon Treaty delivers a very good legal fundament in order to legally, or to enact legally, what the Commission has not been able to do in the past. I will give you a few examples in order to show you this process of legal erosion in the past and the way the Lisbon Treaty, in my opinion, could accelerate this dangerous situation. Some of the examples have already been made in our case. The Maastricht Treaty gives an authorization to the European Commission and to the European Community to improve European networks. Article 154. The European Community has derived from this authorization of improving European networks, that is to say railways or airports, the competence of creating a navigation satellite system costing the European taxpayer about 6 billion euros. So there is no fundament in the European Treaty, in the Maastricht Treaty, allowing such an enormous investment. And it will certainly not remain at 6 billion euros. I don't contest the necessity of having a European satellite navigation system, because otherwise we are too dependent on GPS, and the Americans are friendly with us in sunny times and they are less friendly with us in less sunny times. But I contest and I dispute the authorization of the European Community to spend more than 6 million euros with the aim of creating a navigation satellite system, being incapable of enacting such a system. The European Community has no procurement agency to do this. So this is the start of an enormous waste of money. This is not directly linked to the Lisbon Treaty. That the Lisbon Treaty would have enacted a formal competence for the European Union to conduct space policy. Yeah? So again, my thesis is that the Lisbon Treaty would have prolonged the dangerous tendency which we have already witnessed throughout the practice of the Maastricht Treaty.
Excuse me.
Yes,
I think you said 6 billion and 6 million. Which is it? Which is it?
Billion.
Billion. Thank you.
I'm sorry.
It's okay.
Linguistic mishap. I would like to give you another example of what happens. Let me allude again to the Stability Pact. The Stability Pact was, on a secondary level, the necessity, the condition for enacting the European Monetary Union. It is the implementation, the legal implementation of Article 104. Article 104 forces, obliges, compels the European Community to monitor a public expenditure in all member states of the European Union. Because if all members of the European Union spend as much money as Greece does, the European Monetary Union would be in ruins. Article 104 has been implemented by the so-called Stability and Growth Pact, prescribing certain limits to deficit spending. The 3% deficit related to the gross national product, and the 60% deficit, or the 60% coefficient concerning the overall debt. This Stability and Growth Pact has been implemented by the European Commission in a very soft way. There has never been any sanction. When there was too many sanctions, and when there were too many member states who violated the Stability and Growth Pact, including Germany and France in 2003 and 2004, the Commission simply changed the system and adapted the secondary legislation, that is to say the Stability and Growth Pact, to reality, inviting the member states to adapt in a more subtle way to the monitoring system. As a matter of fact, the Stability and Growth Pact has been buried in this way. Nothing is as dead in Europe as the Stability and Growth Pact. It is inexisting. Sooner or later, that will have great repercussions. The key actor in that context was the European Commission. The European Commission was the accelerator of legal decadence. And that's why we have so little faith in an institution which formally is considered to be the guardian of the treaty. The European Commission has taken the liberty of inventing economic doctrines in order to change the substance of the antitrust law.